Thank you for joining Family Caregiver Alliance for estate planning options, preparing for incapacity, and maintaining home equity. For over 4 decades, Family Caregiver Alliance has been working across the Bay Area and the nation to improve the well being of family caregivers. We offer support through consultations, classes, workshops, publications, research, and advocacy. If you'd like to learn more about us or access our online resource center, CareNav, please visit caregiver.org. Now, during the webinar, your phones and mics are going to be muted, so if you have any questions, you can ask them by using the Zoom Q&A box, and we'll answer as many questions as we can at the end of the webinar. Later on, I'll also be asking for a little feedback, and we'd certainly appreciate if you could let us know how we did. And now I'd like to welcome our presenter, Maura Gibney. Maura is the Executive Director of California Advocates for Nursing Home Reform, which is a statewide nonprofit advocacy organization dedicated to improving the quality and availability of long-term care options in California. Previously, she worked in other social service organizations serving individuals with developmental disabilities and families with children with developmental delays. Maura is a graduate of the University of Southern California Master of Social Work program. And now I'd like to turn it over to Maura.
Thank you so much, and thank you everyone for being here today. I'm going to share a PowerPoint to help us guide the presentation. And definitely, I will leave time for questions if people have any. I think it's probably best to put them in the chat, and then we can, discuss them in the last maybe 15 minutes or so. So again, my name is Maura. I'm the Executive Director for California Advocates for Nursing Home Reform. I'm going to be talking about estate planning options, but I'll also be giving you a little bit of background about our organization and the services that we offer. So CANR is a statewide nonprofit organization. We've been in existence. We're celebrating our 40th anniversary year, and right as a fire truck goes by my office. We are a statewide nonprofit organization dedicated to improving the long-term care system in California. We have a 1-800 number that's on the screen. We offer free consumer counseling and advice on a number of different topics related to older adults and people with disabilities, including planning for long-term care, Medi-Cal, understanding Medi-Cal eligibility, also preventing Medi-Cal recovery. We provide a lot of information about the process for being admitted into different types of long-term care facilities. We answer a lot of questions about transfer and discharge issues when people are in the hospital and facing discharge, or when people are in a nursing home and are potentially facing an illegal eviction from a nursing home. We answer a lot of questions about residents' rights and also home and community-based services. As an advocacy organization, we do impact work through legislation, administrative advocacy with different regulatory entities of the state, and we also engage in litigation. We run a lawyer referral service, which I'll talk a little bit more about in a moment, and we offer a lot of trainings for advocates and professionals around these topics as well. We have a number of free publications on our website at canr.org. We've got over 90 free fact sheets and consumer guides on common long-term care issues. It's a great website. It's recently been redone. You can learn about Medi-Cal eligibility, home and community-based services, different long-term care options, a lot of information on residents' rights and self-advocacy strategies. And we now have a lot of these resources available in 7 different languages. People can also sign up for our monthly news and notes for free. And we also have some great sample forms on our website, including the Advanced Healthcare Directive form, which is free for download. Our lawyer referral service, we're the only California State Bar certified lawyer referral service that specializes in elder law issues. We make referrals to qualified attorneys who specialize in estate planning, residents' rights issues, and protective services, including conservatorships and special needs trusts. So if after today's presentation, you think that you need to meet with an estate planning attorney, you could call our organization and we could initiate a referral to an attorney in your area if we have one on our panel. But to be honest, what we also try to do is provide people with counseling because they may not need an attorney. So definitely we try to save people money. We don't want you to have to pay for an attorney if you don't need one. Okay, so now we'll get into the presentation. First, I'll talk about preparing for end-of-life decisions. We're going to talk a little bit about protecting home equity as well. And so what are some of the common estate planning forms and issues and decisions that people have to make? So first, I'll talk a little bit about probate conservatorships. There are two types of conservatorships that can be filed. A conservatorship of the person, and this is to provide for a person's physical health, their food, clothing, shelter. This is kind of a traditional conservatorship, and a conservatorship of the estate to manage a person's financial affairs. We get a lot of phone calls from people asking for information about conservatorships. Somebody that they're caring for has lost capacity and they're being told that they need a conservatorship. It is really difficult once somebody has already lost capacity, because often conservatorships are the only option, but they are very time consuming and they can cost a lot of money. And unfortunately, there are not a lot of free or low cost options to support people through the conservatorship process. So conservatorships can be a couple of $1,000s and they can take several months. And we do get a lot of calls from people who are kind of under the gun. They've got an emergency situation where they need a conservatorship. And unfortunately, that's typically not how it works. In some counties, there are conservatorship clinics that are run often by a local nonprofit or the court system itself. They have clinics where they'll help people complete the paperwork, but in general, there are not a lot of kind of free legal services programs where you can get an attorney to do a conservatorship for free. So one of the best things that people can do is prepare in advance before someone loses capacity. An option for doing that would be setting up a power of attorney or a POA. This is a legal document that allows for someone who still has legal capacity to appoint someone else to act on their behalf should they become incapacitated. A power of attorney can be immediate. So there's a section where you can say, and I want this person that I'm appointing to be able to help me with these decisions now, or it can take effect once the person becomes incapacitated, sometimes referred to as a springing POA. A durable power of attorney means that the document is effective through incapacity, but it does become invalid once the principal dies. So the POA is a document that helps during the lifetime of the person for issues related to when they lose incapacity. Or I'm sorry, not when they lose capacity, when they become incapacitated. So there's types of power of POAs. The Advanced Healthcare Directive, this is a document. We have a free version on our website. There's a lot of different versions of this. It's a legal form that defines healthcare instructions, end-of-life wishes. A lot of advanced healthcare directives include sections on organ donation, burial wishes. But basically, you can appoint agents, one or more people, to carry out your healthcare instructions while you still have capacity or upon losing capacity. I've included a link here to our free Advanced Healthcare Directive form. We do suggest that people sign the Advanced Healthcare Directive form in English, but we do have instructions for the Advanced Healthcare Directive form available in other languages. The reason why the form should be completed in English and why it's very difficult for people to find the form in other languages is that often the service systems that you would be turning this form into, the doctor may not speak the same language, for example, as the person who's signing the Advanced Healthcare Directive, and you want everybody to understand what the person's wishes were. But we do find it helpful to at least provide the instructions in the person's native language. Another type of POA is a durable power of attorney for financial management. And this is a form that designates an agent or agents to manage your financial affairs, except for those that are in a trust. Financial affairs including properties or other legal matters, So authority can include paying bills and everyday expenses. It could be buying, selling, maintaining property. It could be real estate, collecting state benefits like Medi-Cal or Social Security. It could be handling bank or other financial transactions, paying and filing your taxes and other financial matters. But these are forms that need to be set up in advance before, while someone still has the ability to make decisions for themselves. So we really encourage people to do this as soon as possible and to let people know that they can change. So while a person still has capacity, they can sign a new advanced healthcare directive. They can sign a new POA for financial management. But unfortunately, once someone loses capacity, we often hear from people that their only option becomes a conservatorship, which again is very costly. Key points for understanding powers of attorney. The principal is the person who's creating the Advanced Healthcare Directive or the DPOA. So it's, I, Maura, want to appoint my friend to be, the person that's going to help me make healthcare decisions should I lose capacity. The agent or the attorney in fact is the person who's appointed by me to act on my behalf at the point where I lose incapacity. But, the key is that you have to have capacity to create either one of these documents. And the agent who you appoint also has to have legal capacity. So for example, you cannot appoint your minor child to be your agent for either of these documents. Agents have a fiduciary duty to follow the instructions on the document and put the interest of the principal first. So people, POAs can be held financially responsible if they were to, not administer someone's financial affairs appropriately, for example. And it's important too that for these documents, they require two witnesses, or they can be notarized. And typically the witnesses and agents themselves, the people being appointed cannot be a witness. They have to be two separate people. And best practice would be to also not have the agent, or I'm sorry, the witnesses to these documents be people who have some type of investment or, who could benefit financially from this situation. It's important to note that skilled nursing facility residents, so anybody that's in a nursing home, must also have a signature from an ombudsman. So if you have a loved one in a nursing home and you want to sign one of these documents, it would be important to reach out to the local ombudsman office to coordinate a way to make sure that, it gets signed off by everybody. So what if there is no POA? If there is no conservator, no POA, and someone still has capacity, then the patient can select one verbally by notifying their healthcare provider. For example, my father was in the hospital recently. He did not lose capacity, but he just, wasn't feeling himself and he didn't feel like talking a lot. So he verbally told all the doctors and they put it into the file that while I am here in this health facility, I would like my daughter to be my agent. And then that way they were given, permission to speak with me and I could help him to make his healthcare decisions. What if the patient lacks capacity and has no POA? The patient can have a surrogate that demonstrates special care and concern for the patient and is familiar with the patient's values and beliefs. They don't have to be a relative of the patient. So, a conservatorship, I think longer term, when people are trying to navigate financial affairs and get benefits in line, that's when often we find that people need a conservatorship. But if they're just trying to get health care, there are other probate codes and ways that people can still receive supported decision-making, even if they have lost capacity. So now we'll go into a little bit of protecting home equity. I'll talk a little bit about reverse mortgages and, what do these things have to do with each other, POAs and reverse mortgages, and I'm going to be talking a little bit about Medi-Cal recovery. These are kind of all of the common estate planning topics that come up that we get calls about. and people who are, later in life thinking about their options. So these are, I'm just talking kind of overview of different topics that are of frequent calls that we get. We get a lot of calls from people who, unfortunately, after the fact, have a reverse mortgage and are, unhappy or want to know what they can do. So what we try to do is educate people at the front end to really know the facts about reverse mortgages before they, get in over their head maybe and end up in a situation that they didn't think that they would be in. So reverse mortgages are loans that allow homeowners ages 62 years and older to borrow from the equity of their home. Sometimes these are done in a lump sum. So people take out, a $50,000 one-time lump sum. Sometimes they are payments that occur regularly where the homeowner is receiving regular income from the reverse mortgage. It offers older homeowners cash without having to sell their home or pay additional monthly bills. While the title of the home remains in the owner's name during their lifetime, the loan must be repaid when the borrower no longer lives in the home or dies. And I think that that is often one of the most common things that people don't really think about enough before they sign up for a reverse mortgage. That what does that mean, or do they really understand that upon their death, or if they were to go into a nursing home for longer than a year, the loan becomes due. And so are there other people living in the home? Is there a spouse that still needs to live in the home? Those are just considerations that people need to think about. So it's important to know the risks. Reverse mortgages can be very expensive. There are a lot of fees and costs that are added on top of the balance of the loan. And unlike a traditional home loan where you see all these fees and costs and then they're added up and you know what your monthly mortgage is, people like the idea of getting a monthly payment or a large lump sum. And so they often don't realize on the back end what kind of loan they've built up in the back end, because they're getting they're getting this equity out of their home. Some reverse mortgage funds may be counted as income for the purposes of Medi-Cal eligibility and can increase out-of-pocket costs for the healthcare that people need. So this would more likely be a reverse mortgage that's paying out a regular payment. The lump sum, it kind of depends. It's just something to think about and really be aware of, that you would want to consult with somebody about Medi-Cal eligibility, particularly now that the Medi-Cal eligibility rules have changed, so more people can be eligible for Medi-Cal. And see whether in the future, if you might need to go on to Medi-Cal, how a reverse mortgage can impact your eligibility. Another thing, that homeowners with a reverse mortgage must continue to pay property taxes, insurance, and they have to maintain the home. So failure to meet those obligations can put the loan into default, and the home could be subject to foreclosure. And we've definitely talked to people who got a reverse mortgage, fell behind on their taxes or insurance, and lost their home because they could not pay the taxes or insurance. The bank has the right to call the loan due, and the house was foreclosed on, they lost their home. So it's not to say that, that everybody has a terrible time with reverse mortgages. It's just important that people know what they're getting into before they sign up for it. There are some people who really enjoy the fact that, I worked hard for this house and now I want to live a little. I want to enjoy the equity that I built up in this house. So what happens when a reverse mortgage borrower no longer lives in the property? As I mentioned earlier, the reverse mortgage will require the payment of the loan balance or for the owner to sell the property. And so what we get phone calls sometimes from the children of people who had a reverse mortgage. They end up in a nursing home or they pass away. And now the children didn't realize that there's a $600 reverse mortgage loan balance. They have to come up with, a way to refinance that home, pay off that loan, or they have to sell the property. If there's a spouse who was also listed on the loan, they can stay in the home. But we've had some instances of couples where, one person had good credit possibly, and so the loan was only in the husband's name. The husband passed away, And because the wife was not on the loan had to be paid back or they had to sell the property. Failure to pay the loan balance once the owner no longer lives in the home will result in foreclosure. So again, I don't want to say that a reverse mortgage is, never an option and it doesn't work for anybody. There are definitely people for whom it works for. It's important to know these risks before entering into some kind of an agreement. And every borrower should ask, who is living with you and what would happen to them if you were to get a reverse mortgage? Have you discussed your plan to get a loan with everyone living with you? So, my adult daughter lives with me and her children, and I have a reverse mortgage. But if I had to go into a nursing home, what would my adult daughter do? Would she be able to refinance this loan? Would she be able to pay it off, or are they going to lose the home? If you default on the loan, can you find the funds to catch up and stay current with your taxes, insurance, and home maintenance? And if you end up in a foreclosure, where will you live? Can you afford to pay for a new house, an apartment, or an assisted living facility? So Cantor has some great resources about reverse mortgages. We have a reverse mortgage suitability worksheet that people can use to kind of look at the different risks and see if it's right for them. And we're always happy to answer questions over the phone as well on this topic. So I think I went over some of the concerns, excuse me, still getting over a little bit of a cold, about moving into a nursing home for an extended period. We talked about reverse mortgage loans becoming due. What we are kind of blending here on this slide and going to get into next is the concept of Medi-Cal recovery. So when a Medi-Cal recipient dies, the state of California can seek repayment for the cost of some services received, and we're going to go into more specifics about that. But a reverse mortgage loan can interfere with the ability to transfer a home and avoid a Medi-Cal recovery claim. So again, another consideration, especially now that people might be thinking about going into long-term care, needing nursing home services. But we'll talk a little bit more about Medi-Cal recovery in the next couple of slides and the easy ways that people can avoid Medi-Cal recovery. So what is Medi-Cal recovery? There's a lot of rumors and a lot of myths. Medi-Cal recovery changed significantly in 2017. So we still get calls regularly from people who are aware of old rules that were much more, I want to say, you were at much greater risk prior to 2017. There were many more cases of Medi-Cal recovery. We had a lot of people who lost their home due to Medi-Cal recovery. Due to the changes since 2017, Medi-Cal recovery claims have gone way down. There are only a couple of hundred Medi-Cal recovery claims in the state every year. So there's definitely a way to avoid Medi-Cal recovery, but if people aren't aware of it, then it can be very stressful for people as well and stressful for their families. So if someone was on Medi-Cal ages 55 and older and they use skilled nursing or some specific home and community-based services, the state can try to be reimbursed for the services that were provided. This is not something that happens during someone's lifetime. It only happens after death. So I've gotten calls from people who said, well, I heard that if I get on IHSS, that the state can go into my bank account and take the money back. And that's not true. It doesn't happen during somebody's lifetime. And there's no recovery if there's nothing left in the state or in the estate in the name of the person who received the Medi-Cal. So if somebody doesn't have any assets when they pass away, easy answer, there's no Medi-Cal recovery. They're not going to go after children, for example. I am not liable for my father's Medi-Cal bill personally. The easiest way to know whether there would be Medi-Cal recovery or not is are the assets subject to probate? But most people don't know what probate is. And probate is a court process where a person's relative seeks appointment as an estate administrator if the deceased died without a will, a living trust, and there's no beneficiaries designated on accounts or deeds. There is another way to avoid probate for people who have a small estate. So if someone's gross assets of accounts and cars, their safety deposit box, all together are below this number, $184,500. And that number adjusts slightly every couple of years. Their heirs can avoid probate through a small estate affidavit. It's an affidavit process. So if people do not take steps to appoint beneficiaries or somehow designate and do some simple estate planning, their assets could go to probate. And if they used certain Medi-Cal services, they could be subject to Medi-Cal recovery. Fortunately, there's a lot of things that people can do to avoid Medi-Cal recovery. So when can recovery happen? Again, can only occur if somebody was over the age of 55 and used very specific services covered by Medi-Cal, and that is nursing home services and some very specific home and community-based services that are similar to nursing level of care. There is no Medi-Cal recovery on a surviving spouse, registered domestic partner, or disabled child of any age. So, for example, if you had a couple and the husband was in a nursing home and he passed away, the wife, there is no probate because all the assets go to the wife. There's a surviving spouse, there's no Medi-Cal recovery. And so sometimes when I get these calls and we're kind of going through the what ifs, there's a lot of what ifs, but is there a surviving spouse? Yes. And there's no Medi-Cal recovery. We don't really need to worry about anything else. We don't need to worry about the value of the assets. We don't need to really even talk too much about what services were used. There just can be no Medi-Cal recovery because there was a surviving spouse. Fortunately, in California, that also includes registered domestic partners, and then the disabled child of any age. Let's say the same person who was in a nursing home passes away, has a disabled child age 40 years old, there's no Medi-Cal recovery. There's no recovery if assets are protected by estate planning, including living trusts, if the home was held in joint tenancy, if bank accounts were set up as pay on death accounts, which is a type of designation that you can do with your bank, if things are held in life estates, there's no recovery because then that means that those assets will not go to probate. Other assets that are exempted from recovery include mobile homes. There is absolutely no recovery on mobile home. It does not matter how it's held. And retirement accounts when there's a beneficiary designated or life insurance policies where there's beneficiaries designated. And fortunately, most retirement companies and life insurance policies, they make you designate a beneficiary. So if you're wondering right now, oh, did I designate a beneficiary? You probably had to. It was probably part of the process when you signed up for either one of those, either that policy or that account. And then a homestead of modest value. If the property value is 50% or less than the average price of a home in the county where the homestead is located. Now in California, that can, sometimes be difficult, but we have had cases where people did have a recovery claim, but the house was in such disrepair, we were able to show that as compared to other homes in the area, this home was just not, not worth as much because it needed so much repair, and the person was able to avoid recovery. The goal, though, is not to try to fix the issue afterwards. The goal is to really try to take some simple steps to make sure that the person's assets are protected. And it's also important, we get a lot of phone calls, my mom is going into a nursing home tomorrow, but we don't have her home in a trust. It doesn't have to be done before, you don't have to protect your assets before you use the service. You just have to make sure that things have been properly set up before the person passes away. So if someone's in a nursing home, it's not too late to do the estate planning to protect these assets. So probate can be avoided if assets are held jointly with someone else. So this could be joint tenancy on a property. It could be, a bank account that's held jointly, or as survivorship community property with a spouse or domestic partner. Again, beneficiary designations in retirement accounts, brokerage accounts, life insurance. You can call the bank and make sure that bank accounts are set up on payable on death accounts. And then that way, as you know, when the person passes, there is no probate. It just goes to whoever that beneficiary that you designated. Transfer on death deeds for real properties, and people can make sure that assets are in a revocable living trust. It's important to make sure that living beneficiaries are listed on the accounts. Make sure that your beneficiaries, that you're keeping those updated. Otherwise, probate would be required. So I'll talk a little bit about a last will and testament. We do get people who call us for referrals because they want to set up a will. A last will and testament, commonly known as a will, is a legal document that people can use to plan in advance about how they want to leave their assets and property to. A will can also name a guardian to care for minor children, can name a trusted person to manage property left to minor children, and name an executor, the person entrusted with carrying out the terms of the will. Unfortunately, a will does not avoid probate and so will not help avoid Medi-Cal recovery. So I think, a will could be useful for somebody who maybe has a small estate and who could avoid probate through the small estate affidavit, for example. If you have somebody where combined assets are $100,000, they're below the small estate cap, which currently, again, is at $184,500. A will would be fine because there's a way for the family, the heirs, to avoid probate through a small estate affidavit. So they're not going to have Medi-Cal recovery. I mentioned irrevocable living trusts because previous to 2017, there was a lot of estate planning around irrevocable living trusts because it was one of the ways that people could avoid Medi-Cal recovery. An irrevocable living trust is created to reduce taxes and avoid probate. But it's important for people to understand that when you set up an irrevocable trust, you lose ownership of the assets included in the trust. And so post 2017, we really want people to be aware of advice that an irrevocable trust is the only way to avoid recovery, because it is not. They are incredibly expensive, that you lose your own ability to control your assets, and irrevocable means it cannot be changed, it cannot be reversed or recovered. It is final. So an irrevocable living trust, we don't see people needing this as frequently because it is not the primary way to avoid Medi-Cal recovery. One of the most common ways is a revocable living trust. And this is a document that's created during a person's lifetime, that as long as they have capacity, and it enables people to manage their assets while they're still alive, and then set up instructions about how they would like them to be distributed after death without going through probate. So this is a very common way of avoiding Medi-Cal recovery. A revocable living trust offers greater privacy. So a will can be accessed by the public while a trust document is typically private. And what's really important about a revocable living trust, allows you to maintain control over the property that's in your trust. So you still keep control over your finances, your assets, your home while you're still alive. It also helps you to set up plans in advance in case you lose capacity. A lot of revocable living trusts can also include a POA provisions as well. It provides better protection from court challenges, and it definitely prevents Medi-Cal recovery. The downside for a revocable living trust is that it can take time, and it can be expensive to both set up and maintain. So people who pay privately for a revocable living trust, I'm not an attorney, so I can't tell you what the current prices are, but I've heard something in the neighborhood of $5,000, but it also depends on the amount of assets that would be going into the trust. So, it can be quite pricey. But it's important to remember that a revocable living trust versus irrevocable, revocable can be changed, it can be updated. Irrevocable, you're giving your assets away and it cannot typically be changed. A few resources here. We have a fact sheet on preparing for incapacity. A lot of people don't want to think about this. They don't want to think about becoming incapacitated. These are really difficult conversations. These are really difficult decisions. But I think all of us who are caregivers for our parents, definitely going through what I've gone through with my father recently makes me really been really talking with my husband about what we want our decisions to be, who we want our agents to be, and what we want our end of life decisions to be. So the sooner the better. Definitely, we have a lot of resources on our website. We have a great Medi-Cal recovery guide on our website. It's actually now available in 6 different languages. And it tells people about, the facts and the myths about Medi-Cal recovery. It is definitely avoidable. There are simple steps that people can take to plan in advance and use Medi-Cal and use all the services that they need, but also, feel safe that they are going to be able to pass down their estates to their loved ones and their family. I'll mention that there is some low-income estate planning support. Now, not on the conservatorship side, but on the revocable living trust. HERA, California offers low cost and sliding scale estate planning. They do take some time, but I think for people who cannot afford private estate planning, it's a wonderful resource. As long as you have the patience, it's going to be worth it. So I've heard of people, based on their income, getting a full, trust and estate plan done for $70. So I would say that that's worth having a bit of patience for. And then for people that, want to talk with an attorney and can afford a private attorney, please contact Canner. We have a lawyer referral service that's certified. We can refer you to an estate planner who's trained in these matters, who can talk with you about estate planning and how to avoid Medi-Cal recovery and other topics as well. Okay, so it looks like we have plenty of time for questions, and I do know that there's some questions in the chat, and as well, people that are raising their hands, but I will let our coordinator help me to sort that out. I'll stop sharing my screen.
Sure, thanks, Maura. Yeah, we have a couple of questions. Let's see. We have a listener who wanted to know they spent about $2,000 setting up a revocable trust about 15 years ago. They want to change out a few of the beneficiaries. There's a lot. There's almost 15. They're saying the lawyer wants to charge them about $700 to add 3 names and take away 4 names. Is this something they can do themselves and get it notarized, or do you have to go through a lawyer to make those changes?
My understanding is that you do have to have a lawyer to update your trust. We do have, if you really would like to know a little bit more about that process, we do have an estate planner on our staff who would not do the work, but you could at least ask that question and feel a little bit more secure that it's, worth it. So I would, if you'd like, call our offices and you can ask to speak with an attorney just to kind of run that scenario by them. But that is my understanding. You have to have, there's different paperwork that can only be filed by an attorney.
Okay. Actually, we had another listener who was wondering actually if you could put your contact information up again.
Yeah, definitely.
Actually, I guess we might as well just leave it up so people have
Yep.
can always refer back to it. Okay, great. Let's see. We have another listener. Actually, this is a question that was asked during the registration. It's a little. It's not exactly related to this topic, but it is related to what you all do as an organization. They must have done
Yep.
a little research beforehand, but they wanted to know if you have any tips on how to select a nursing home, because I think often we hear about kind of stories of less than stellar care. Are there things to look out for, red flags, or is there kind of a process or a checklist that people might consider doing when they're looking for a nursing home for a parent or a loved one or a friend?
Yeah, definitely. That's a great question and a very common one. So we have on our website some checklists and fact sheets about exactly that, what to look for in a nursing home. Our advice is to try to visit the nursing home. I think there's nothing better than a gut feeling. I think also another key point, there's a long list. There's a long checklist. There's so many things you could look for, but I think gut feeling and smell. Smell is a really great indicator. Does it smell, unfortunately, like urine? How often are people being changed? Are people being cleaned on a regular basis? I think it's important to mention that while there is a long checklist of things to look for in a nursing home, it's also important to understand the system of placement in nursing homes in California. Practically nowadays, you cannot get into a nursing home unless you're being discharged from a hospital. So oftentimes people don't have the choice that they did even 10 years ago, where you could say, these are the three kind of nursing homes in my county that I'd like someone to go to. The nursing homes kind of control who they offer a bed to. And oftentimes families are really put in a pressure situation. Their loved one is in the hospital, and there's one nursing home in their county that's willing to take them. And do they have the time that day to go to that nursing home and go visit? So it's hard to even say, this is the checklist, go visit, because the reality of how nursing home placement is working right now isn't always conducive to visiting ahead of time and kind of getting enough time. I would say that there are things to look for. You can go on the Department of Public Health has a website, a database, and these are all linked to our fact sheets on our website, where you can look in advance, kind of at a glance. It'll show you the nursing home's record of citations and complaints as compared to the state average. I was looking for a nursing home for my father recently, brought up the facility that they were offering. And I mean, I didn't need to get too far into it. Right off the bat, this facility had double the statewide average of complaints, triple the statewide average of citations. There's no way I'm sending my dad to that facility. I don't really even want to get into anything else, So the problem too, though, is for people who have no other option, they cannot go home, that sometimes people really are forced into, taking the facility that's being offered. So it is important. It's great to kind of do your homework, have a sense of what maybe a couple of your top nursing homes are in your area. Should you be in that situation, and then you can talk with the hospital discharge planners. These are the facilities I would prefer, and then have them really concentrate their efforts there. But sometimes that's not the way that we're seeing it work.
Okay, thank you. Yeah, I did not realize that actually.
Yeah.
We have another listener who wanted to know their mother has a revocable trust, and the person who's asking the question is the trustee. The mother makes about 5,000 a month with Social Security. The trustee, the adult child, has been giving the mother a salary, in quotations, from their LLC's income. So the mother makes about 31,000 a year, and the mother's LLC makes an income. So would she be able to qualify for Medi-Cal when she needs a higher level of care? I don't know if that's something you can answer just off the top.
Yeah. I'm so would she be eligible for nursing home coverage? I think is the question. And the answer is yes. It's important to know how share of cost works. So in a nursing home on Medi-Cal, practically, especially now, if you haven't heard, January 2024, Medi-Cal no longer considers assets for any Medi-Cal program in determining eligibility. So really now it's solely based on income. So income was a factor previously, that has not changed. So you could have somebody, it sounds like this person, if I understand, 5,000 a month in retirement plus an additional, $2,500 from the LLC. What I would say is that it's important to understand that in a nursing home, everybody, regardless of their income, pays a share of cost. And it is practically all of your income. And you only keep $35. There's a couple of people who get to keep slightly more, but we're not talking a lot of money here. And the money that you need to maybe keep paying for any healthcare premiums that you like. So by and large, people cannot keep the income that they've been getting. So when we hear about those situations where someone has their retirement, we know that is definitely going to go towards the share of costs. But these other payments, if there was a way to stop making those because they're only just going to get paid towards the share of cost. So I don't know, maybe, and I, want to talk with the person a little bit more about do you have to pay out proceeds to the beneficiary? Because if not, I wouldn't, because it's just going to go towards share of cost.
Okay, we have actually another related question. They wanted a listener said that they know that Medi-Cal eligibility rules were changed around January of this year. Um, would you be able to? Are there? I guess if you could comment on that, and also they wanted to know when applying. Sorry if you already explained this, but I have a little bit of trouble keeping this all straight in my head.
No, it's okay.
Also, when applying, does the spouse income, Social Security, etc., count as income on the application?
Okay, no, those are good questions. So definitely asset limits changed. There's no longer an asset limit. I think what we're getting a lot of phone calls is this a drastic change to Medi-Cal eligibility? Yes, it is. Previously, if you had 2 cars, you would not be eligible for Medi-Cal. That's a little silly. What if my second car is a complete clunker? So that those rules have changed. So what is important to know is that income rules have not changed. So for many people, Medi-Cal could still be quite unaffordable because in the community, there's an income limit and you're either below it or above it. There's a little bit you can do to kind of bring your accountable income down. But if if you make $5,000 a month and you're going to live in the community and you need Medi-Cal, you're going to have such a high share of cost. Not to say that there aren't scenarios where it could still be helpful, but your share of cost would be so great and you're going to have so little money left to pay for your living expenses. For people in a nursing home, Medi-Cal, kind of regardless of your income, can be helpful because the private pay in a nursing home is so high. Yes, it is important to note that there are special rules for married couples and registered domestic partners, where if one person in the couple is high need and either needs in-home care services or needs to go into a nursing home, these special rules can help the person in the couple who doesn't need Medi-Cal keep either all of their own income or get additional income from the Medi-Cal spouse. They're called spousal impoverishment protections. And what we're hearing across the state is that Medi-Cal offices do not know these rules. So by and large, people have to be really well aware. And so those are the calls we get every day. Call us. Let's talk through your income scenario and let's kind of at least get you an idea of what the estimated share of cost would be, or possibly no share of cost. And then that way, when you do apply for Medi-Cal, it'll be easier to identify if they've done something wrong and easier to fix it. So we have some good fact sheets about spousal impoverishment on our website as well.
Thanks. We have another question in the chat. They wanted to know, you actually gave the example of your father about how they wanted to place him in a nursing home that had extremely high levels of citations and complaints compared to the average. So they want to know, how do you work with the either nurse, social workers who are going to place a parent from a hospital to a nursing home to find a different place if the one they choose is unacceptable to you?
It can be really challenging, and the best advice is to really rely on go back to health and safety of the individual, health and safety of your parent or the person in need of the services, and when possible, put it in writing. So for example, my suggestion is to look up, I'm sorry, there's a person outside of our office who's having a difficult day. But hopefully she's moving down the street. To put in writing, for example, that I have extreme concerns that this facility would not be able to appropriately provide for the health and well-being of my father. More often than not, what we hear about is people being offered a placement that is 100 miles away. So another placement option that was offered for my father was, oh, we found him, he's in San Francisco. We found him a facility in Sacramento. I was like, no, we're not going to Sacramento. We have sample letters that we provide to people that offer some of the regulations about, not, and so people's often their first instinct is to say, well, I can't drive to Sacramento. And then the discharge people get to say, oh, well, the family was being difficult and they wouldn't, it was all about them. No, yes, it's very inconvenient for a family member to have to drive to Sacramento, but the phrasing is, and we provide counseling about this all the time. It would be detrimental to his health and well-being because family members who are an integral part of his, care plan would not be able to visit regularly. And we feel that this would be, so there's wording that you can use. And so it can be really difficult because the hospital discharge planners, their job is to get the person out. So you really have to, use whatever leverage you can, keep the person there until you find an ideal placement. And it can be difficult. We've had people who have been told all kinds of things about how they're going to be, they will be responsible for a private hospital bill. But we do have sample letters that people can use when they're working with the discharge planning team at the hospital.
Okay, we have two questions about Medi-Cal eligibility income. One wanted to know, is it correct that the Medi-Cal eligibility income limit for a single person is $1,725 per month? Well, maybe if you could answer that first, and I have another quick question that might have the same answer.
So currently it's 1677 if we're talking about the programs for older adults and people with disabilities. That the number is 1721, I believe, and every dollar counts. If you're a dollar over, then you have a share of cost. And it will increase on April 1st. So for non-Magi programs, if you're at all familiar with the Medi-Cal world, the programs that older adults and people with disabilities are most often on, for fun, the income guidelines aren't effective until April of every year. So right now, today, it's 1677, and April 1st, it'll be 1721. Now, if somebody makes $2,000 a month, are they over that amount? Yes. Is there something that they can do to bring down their countable income down to 1721? Yes. They can lower their countable income through the purchase of supplemental health insurance policies. So for example, they could buy a dental plan, Medicare Part D drug plan, any kind of health insurance policy can help them lower their countable income. But there's another population of people that are making $5,000 a month. There's just no way. You can't lower your countable income. You cannot avoid a share of cost. And then for people in a nursing home, you cannot avoid your share of cost completely.
Okay, and then as a follow-up, again, I apologize if this is pretty much asking the same question, but I'm
Okay.
not 100% familiar with. I get this stuff confused often. Another listener wants to know, what is the income limit for one person high need in a couple? Would that change at all? Which the answer you just gave?
So for spousal impoverishment, we get that question a lot. That I was told that the income limit and the income there isn't for the. It would really be important to talk through every couple scenario, married couples, registered domestic partners, because there isn't an income limit per se. That same income limit applies. What spousal impoverishment does is it allows the well spouse, the spouse that's not going to use the Medi-Cal benefits, to keep any amount of income that's in their name only. Or if they are low income and they're under this threshold, and it's a figure that changes every year. It's called the EMNA. And because I'm sharing my screen, I can't get, but it's around, it just increased. It's around 3,800 and some change. That figure changes every year. That's not the income limit. If they make less than that, then they can be allocated money from the spouse that's on Medi-Cal. And the point of that is so that the spouse on Medi-Cal can either avoid a shared cost or reduce their share of costs. And the goal is to keep the spouse who's not on Medi-Cal from falling into poverty. It's called, spousal impoverishment protection. So it's to prevent them from losing their home, prevent them from becoming homeless. So there isn't per se it bothers me sometimes when I hear professionals tell people, oh, well, for spousal impoverishment, there's an income limit. We've had scenarios. I helped a woman last year. She ran a home health agency. She was very successful and she was making like $9,000 a month. And she was, but she had a mortgage. She had cars. She lived in San Francisco. She had kids. Her husband had a brain aneurysm. He was working perfectly healthy, and he became permanently disabled one day to the next. I mean, so spousal impoverishment, what that does is she can keep all the income in her name. If he, eventually was probably going to end up getting some kind of, disability related income or something like that. He would have his own, share of cost for nursing home services, but it at least allows her to continue. And that was exactly it. She's being faced with a private nursing home bill of $15,000 a month in San Francisco. And she's going, well, what do I do? Well, great news. There's these special rules that can help a couple like yourself. So we just really encourage people, if you've got a married couple or you are, or you're a professional working with a married couple or registered domestic partner, please just contact us with the income scenarios. I will say personally, spousal impoverishment, it took me like 4 months to really wrap my brain around these different, like what you do this, and then you do this, and then you subtract this from here. It's this kind of math equation. And if people get it wrong, then, they're led to believe that maybe Medi-Cal is not possible. And for many married couples and registered domestic partners, it is.
Okay, thanks. We have maybe time for one or two more questions. Definitely one more. This is actually a clarifying question about the first part of the question you just answered. So, if over $1,721, what is the share of cost? Does that mean it's everything over the $1,721?
That's what we would like it to be. I wish that was the answer. And we ran legislation last year with other advocates to try to make that the case. But that did not, it passed, but it's subject to allocation. So long story. Unfortunately, what's called the maintenance need for community-based Medi-Cal, it is only $600. So it is, if you make even $1 over the income limit, then Medi-Cal says that you owe everything over $600. You're only allowed to keep $600 to pay for your living expenses, your rent, your mortgage, your food, your bills, your utilities, and everything else above that is a share of cost.
Got it. Okay, thank you. Okay, maybe time for just one more simple question. Will they have will you be able to share the slides from today's webinar?
Definitely. I will send those over immediately after this, and I'm sure they can be distributed to everybody.
Yeah, yeah. Okay, so I can get it over to people who registered.
Mhm.
So, okay. Well, I think that's about all the time we have for today. I do want to set up one very quick poll again, and we'd certainly appreciate if you were able to fill this out